So in Frontiero v. Richardson, we've moved forward 2 years in time, and we've had a new member join the court. Justice William Rehnquist has joined the court at this point. So whereas the previous case was unanimous, this case is 8-1 with Justice Rehnquist dissenting. So let me give you a bit of the background for this case. So federal law provided an automatic assumption that the wives of men in military service were dependents for issues such as health insurance and home accommodations and other things like that. But a woman could make no similar claim unless she proved that her husband was dependent upon her for more than half of their support. So the law automatically assumed that women were dependents when it was a men claiming the benefits, but it did not assume that the husband was a dependent when it was a woman claiming benefits. So a woman, Frontiero, sought extra quarters allowance, which is simply larger, more private living spaces because they're married, along with basically health benefits for her husband, insurance. They argue that the law, as it situates, is simply unconstitutional. So the question is, does this federal law, which treats male service members different from female service members, a violation of the Equal Protection Clause? The Supreme Court 8-1 says, absolutely, this is a violation of the Equal Protection Clause. But that is not as simple as the case is. There are 4 justices on the court, so not a majority. There are 4 justices who claim that all gender-based classifications are inherently suspect and thus necessitate a strict scrutiny type of analysis. So understand, in the previous case, the court didn't weigh in on what level of scrutiny should be used. Now in 1973, there are 4 justices who go, well, there exists rational basis. There exists strict scrutiny. There are these 2 sort of very different types of analysis that should be taking place, and 4 of the justices say, yes, absolutely, we should use strict scrutiny. Justice Brennan, Justice Douglas, Justice White, and Justice Marshall are all of the ones arguing that strict scrutiny should apply in this case. Understand that exactly past this time, the ERA has been passed by both houses of Congress. It has gone to the states. Not enough states have ratified it yet, but we're early on in the process. It's 1973. The deadline isn't until 1979. Congress has overwhelmingly passed the Equal Rights Amendment. The writing on the wall seems to be there that the Equal Rights Amendment is going to become law. Had the Equal Rights Amendment been added to the Constitution, gender-based classifications would have absolutely been subject to strict scrutiny. So these 4 justices might be forward-looking to what seemed the inevitable passage of the Equal Rights Amendment, and simply articulating a standard of review that would have been mandated by the constitutional amendment. There are 4 other judges in the majority that agree that the law is constitutional, but don't agree with using strict scrutiny as the standard for review. Justice Stewart agreed that the statute in question was absolutely invidious discrimination and was unconstitutional based on the precedent in Reed. But Justices Powell, Berger, and Blackmun, all of whom were Nixon appointees. Remember when I said that this was a Berger court that was more conservative than the Warren court? Well, Justices Powell, Blackmun, and Berger, all Nixon appointees, all conservative, made the argument that it was unnecessary to claim gender as a suspect classification because this case, based upon the precedent they established in Reed, would already be struck down. The law would already be struck down based on the precedent in Reed. There was no reason for them to sort of take the step to implement a strict scrutiny standard based on gender when previous case precedent would already strike down the law in question. They also, in a sort of pretty rare move, but I think circumstances sort of dictate it, point to, in their opinion, the political process that is taking place. They literally go, look, the ERA is at the state legislatures. It's there. And so if the state legislatures ratify the Equal Rights Amendment, it'll absolutely have to be strict scrutiny. There's no question. But if we move before the state legislatures and institute strict scrutiny, then we've basically taken the job away from the state legislatures. And it's not our job to do that, especially while the political process is still playing out. So for justices who want strict scrutiny, for justices who don't want strict scrutiny, or at least don't want it now, and then there's Justice Rehnquist, who is the sole dissent in this case. Justice Rehnquist claimed that the statute was not a gender-based classification, that the statute in question did not classify based on gender, that it classified based on marital status, which it's an argument. I'm not sure if it's a persuasive one. He also says that, well, if it even was based on gender, gender's not a suspect classification, and we have no precedent by which it does say that it's a suspect classification. So if you use the rational basis test, which means that the government simply has to articulate a legitimate purpose for the distinction made, that simple administrative convenience would be a reasonable enough reason to keep the statute. And therefore, in his mindset, the statute itself was not unconstitutional, that the statute could go forward. So in Frontiero, what we have is we have a significantly large majority, 8, who agree that the statute in question is absolutely unconstitutional and a violation of the 14th Amendment Equal Protection Clause. But what they can't agree on, what they can't settle on, and there seems to be a pretty distinct separation on the court, is what level of review these gender-based distinctions should be subjected to. And it would be sort of ahistoric to try to take this case out of the time in which it was happening. The Equal Rights Amendment is the thing being discussed. For those of you who haven't lived through a constitutional amendment process, amending the Constitution is kind of a big deal. And it's going to be something that is actively discussed and actively talked about, which is why we probably see a discussion of the process in this opinion. And so what we have in this case is we know that the court is inclined to strike down gender-based distinctions. But we don't know as why. And that's because the court hasn't provided us a standard. Both in Reed v. Reed and both in Frontiero, the standard is it invidious discrimination? And the answer in both cases is yes. But that does not... the most intelligent among you would have difficulty telling me what is invidious discrimination and what isn't invidious discrimination. That invidious word, it's not really exacting. And so it isn't until the next case that the court finally settles on a standard that still now is the standard by which laws that make gender-based classifications are subjected to in courts of law.